Start at 1:30. I'm told that several of our members are presenting or listening to bills in other committees, so we're going to start as a subcommittee. I apologize for that. If you are here on file item 3, SB 161 VIDAC, or item 5, SB 308 by Senator Wojtkowski, both those bills have been pulled from today's agenda. So unless you really just want to sit here and hang with us, you are free to leave, and I think those bills, when they are renoticed, will be back here for consideration, but not today. Additionally, we have 2 items on the consent calendar. Item 4, SB 269 by Senator VIDAC, and item 7, SB 470 by myself, Senator Jackson. Those are consent items, and again, if you're here on those, we're happy to have you stay or leave at your discretion. So we're going to turn now to the bills that are before us. We generally go in file order, but Senator Bell is chairing Transportation, which is hearing Senator Leno's bill. So that's why we're going to move forward with SB 34 by Senator Hill. Again, we'll start as a subcommittee, and as soon as we get a quorum, we'll establish that, even if you won't mind if I interrupt you, if we're able to do that. So, good afternoon, Senator, and welcome.
Thank you very much. Good afternoon, members. I'd like to discuss the technical amendments listed on page 10 of the analysis. SB 34 establishes reasonable privacy and transparency requirements for the use of automatic license plate readers. The technology is a useful component of modern policing, but the increased use of this technology has raised concerns over civil liberties and privacy. Current law addresses license plate readers used by the CHP and transportation agencies, but it ignores local law enforcement and private uses. In absence of statutory protections, organizations using the technology have also been slow to create their own internal policies. For example, only 48% of police agencies across the country have developed license plate reader policies. Here in California, very few local agencies that use the technology have policies, and very few provide an opportunity for public input when approving the use of license plate readers. Out of the 57 local agencies known to use license plate readers, only 16 have a publicly available policy, and only 8 have an opportunity for public input. The public should be able to weigh in on the use of this technology within their community, and at the very minimum, agencies should be required to have a policy about how and when license plate readers will be used. SB 34 updates California law to do just this. First, the bill requires a public agency considering the use of license plate readers to provide an opportunity for public comment at a regularly scheduled public meeting of its governing body. Second, public and private entities that use license plate readers must adopt a privacy and usage policy and post it conspicuously on their website. The policy must contain specific issues laid out in the bill, such as how the license plate readers will be used and how long the data will be kept. Third, the bill requires operators to keep a record of when license plate reader data is accessed, including the purpose of accessing the data. Lastly, organizations that store license plate data must protect the data with reasonable security safeguards in order to both ensure the data's integrity and confidentiality and protect the data from unauthorized access or disclosure. The bill takes reasonable steps to make sure Californians' civil liberties and privacy are respected and protected, while still balancing law enforcement's ability to use license plate readers to catch criminals. SB 34 is supported by the California Civil Liberties Council, Conference of California Bar Associations, and Small Business California, and has no known opposition. Respectfully ask for your aye vote, members, and thank you. Senator Vice.
In support.
Mr. Chair, thank you. Good afternoon.
Larry Doyle, on behalf of the Conference of California Bar Associations, we think it's an important privacy measure and urge the committee's support.
Any witnesses in opposition? Questions or comments? I got one question. I've got on my license plate, I've got my last name. What danger am I in?
What danger are you in?
Yeah.
You're in trouble. Well, I mean, I don't know if you're in danger, but certainly your last name was only no different than my wife's last year when I paid a private investigator to, with her permission, to find her. And they found her vehicle. Actually, it was in Sacramento and Natomas. She goes to exercise once a week, and they found her car on private property. Picture of the back of her vehicle with that license plate, so your name would be shown there, as well as the longitude, latitude, satellite view, an image of where the vehicle was. So with your name there, that'll make it easier for them to identify who you are. That's all.
Any other comments, questions?
No. Very good.
Okay.
Thank you, Mr. Meyer. Very good. Thank you, Mr. Chair. Appreciate it, and respectfully ask for an aye vote at the proper time. Thank you.
What do we got next?
I didn't see the chair. I was confused. Pardon me. Just because.
Oh, that's nice.
Just because I could.
Okay, next item, number 6, SB 316. Senator Mitchell.
Mr. Chair and members, thank you very much for the opportunity to present this bill that ensures that dependency court attorneys can properly serve the foster care children they are appointed to represent. There are 74,000 plus children in foster care in California. Each is represented by a court-appointed attorney who is charged with the sole responsibility of advocating for that child's safety, protection, and physical and emotional well-being. For a child in foster care who's been removed from his or her home because of physical and/or emotional abuse and neglect, having a competent and dedicated attorney is critical. A child's attorney may be in the best position to prevent horrific outcomes. Through the dependency court, the state makes decisions that have huge implications on the child's life and future, such as whether the child will ever return to his or her parents, be placed with siblings, where and with whom he or she will live, and what services she will receive. In 2008, a California Judicial Council study concluded that the basic caseload standard, where the attorney is supported by a social work investigator, is a maximum of 188 child clients, while the optimal is 77. Yet here in our state, overwhelming caseloads make it impossible for the dependency court-appointed attorneys to properly serve their child clients. In my home county of Los Angeles, where the largest number of foster children in the state are served, the average dependency attorney's caseload is 300 children per attorney. In 15 of California's counties, the caseloads are even higher. SB 316 will ensure that counsel representing a child or a non-minor dependent will not have a caseload that exceeds the ideal of 77 clients, unless that counsel has the assistance of a social worker or investigator on a half-time or more than half-time basis, and that counsel's caseload could not exceed 188 clients. Today with me is Ed Howard with the Children's Advocacy Institute to testify in support of the bill.
Good afternoon, members. Ed Howard, Senior Counsel with the University of San Diego School of Law's Children's Advocacy Institute. Your analysis gets it exactly right. On the bottom of page 2, it says, the state of California has a responsibility to ensure that every child or minor dependent in our foster care system is fully and adequately represented in dependency court, as the child does not have a voice of their own. How well are we doing? According to information provided by the Judicial Council to Budget Sub 5, the caseloads in some of these counties are grotesque. 500 children per lawyer in Ventura County, 456 in Tulare, 461 in Riverside, and as you've already heard, well over 300 in Los Angeles County. I confess that I talk for a living, and it is a challenge for me to explain the importance of this for California's 70,000 some odd abused and neglected children. Over the years, my organization has asked you for votes on foster care bills, and we will ask you again for votes on foster care bills, but nothing, Mr. Chairman and members, compares to this. Nothing. Because more than any additional government program or tweak or reform to current law, more than anything else, what these children need is to be children. And after invading a home by blunt force of law and removing these children from the care of their parents, being a child for such children means not having to shoulder the preposterous burden of being their own advocate in a baffling and impersonal bureaucracy where they have no power as against the adults who rule their lives, no voice, no comprehension. To be a child means, by definition, to have one, just one, please, just one adult in their lives who will not disappoint them. Just one adult who will be their champion. Just one adult in all of their lives who can look down at a frightened child and whisper with a smile, "I got this," and mean it. Only then will our foster children, and they are our children as assuredly as my daughter Maya, 12, and my son Noah, 16, are my own. Only then will they be able to be children. The psalm says, "A father to the fatherless is God in his holy habitation." I do not just ask for your aye vote today on behalf of the frightened and otherwise helpless children to whom we owe a responsibility like no other. I implore you on their behalf to vote for this bill and to make sure that this happens. Thank you.
Any other witnesses in support? Witnesses in opposition? Questions, comments, sir?
Thank you, Mr. Chair. I want to thank Senator Mitchell for bringing this forward. Even the stated objective here of 77 clients per attorney sounds like a heavy caseload. And just so I'm clear, we've been focused in some other committees on the dramatic increased rate of psychotropic drugs being ordered for minor children in foster care. These are the same attorney advocates who would also represent that child in a court determination about prescribing or changing psychotropic drug prescriptions?
Yes, sir.
So in addition to issues of custody, placement, education, and other welfare issues, part of this caseload can and will include being a voice for that child. We've learned children as young as 6, 7, 8 years old being prescribed multiple psychotropic drugs in foster care. So this is not the Appropriations Committee. I'm fully supportive. I applaud the efforts of you and the advocates. But just out of curiosity, do you have any sense of what it would cost to reduce caseloads to this level?
I don't at this time. If you recall, Senator Monning, this was a part of the request from the Chief Justice a year ago to reduce caseload. It wasn't just for the Council for Children. It was a broad. It was to include parents. And so I can't use that dollar figure alone here. And so I don't have it yet. Mr. Howard?
We don't have an exact
Again, that's
number.
not the province of this committee.
Right.
I'm just curious because I expect there's going to be broad policy support, and our challenge
will be
The
finance.
other issues will be budget. But I think there can be no more compelling case than the welfare of the state's children. Thank you.
This is perfect timing to establish our quorum, and then we'll go ahead and Senator Anderson will have a question. Very good. Please call the roll.
Jackson.
Here.
Jackson here. Vidak. Here. Vidak here. Anderson. Here. Anderson here. Hertzberg. Leno. Monning. Here. Monning here. Wykowski.
All right, we have established a quorum, and good afternoon, Senator Mitchell.
Good afternoon, ma'am. And if I could just respond.
Please, and then Senator Anderson. You bet.
Excellent. And correct me if I'm wrong, Mr. Howard, I completely agree with your point. Senator Monty, we shouldn't think of it as an initial point for representation when the child comes in to the foster care system. They are their counsel throughout the course of their experience. And so you're absolutely right. Whatever the case may be where the child needs representation as they navigate their way through the foster care system, this is their representation. So the point you've made in terms of the correlation with their need for representation in terms of medications across the board, you're absolutely on target, sir.
Just to drill down, if I could ask one other question. So the goal of 77 clients per attorney, but we hear in the testimony 300, 400, 500. How do attorneys manage the current caseloads with any ability to interact with the child they're charged to represent?
If I may, Senator.
Please.
They can't. It is one of the more moving experiences of my life to go down and visit with the lawyers in Los Angeles County. These are God's own people who go to law school, do this work for very little pay. They do it because of their passionate dedication to the less fortunate, to the least among, literally the least among us. And they can't do their jobs, and it breaks their hearts. Sometimes they meet their child clients for the very first time before the most momentous proceedings of their lives, minutes beforehand. And remember, these are abused and neglected children who have a very good reason not to trust the adults that surround them. By way of reference, to underscore how preposterous a caseload of 300 is, imagine one of your staff. I had the privilege of serving as staff in this building for 5 years. Imagine one of your staff with 300 bill binders in your office. It's impossible. And even if they were all spot bills,
Right.
it would be impossible. It's inconceivable what is happening now. And to drill down a little bit even farther to your point, Senator Monning, it's not just psychotropic drugs. The reason why I with confidence can tell you that nothing compares to this is because it doesn't matter what laws that you write. It doesn't matter what laws that I sponsor. If there's nobody there to ensure their faithful implementation with a three-dimensional understanding of the needs of that individual abused and neglected child, the law it doesn't matter whether it exists or not.
And thank you. And I would imagine, just a final comment, our primary interest in this bill is the welfare of the foster child. That said, the service of these attorneys, they're going to be more likely to burn out or look for another job. And so you lose people that have skill and that passion because you give them expectations that can never be fulfilled.
And we heard that loud and clear when this issue was before the budget subcommittee that I served on last year, sub 5, when it was being considered in the context of the budget process. And they came up during public testimony and spoke very passionately about just that issue, about having a vision and wanting to serve a population, but really just not having the capacity to do so because of caseloads. As I said before, this is a part of the request made by the Chief Justice of us. It was heard through the budget process last year. The governor didn't support it, and that's why we're coming back using our legislative opportunity this go-round.
Thank you. Thank you, Madam Chair. I'd like to move the bill at the appropriate time.
Very good. So noted. And I'd just like to add that most of these dependency attorneys are women as well, who are terribly underpaid, overworked, juggling their own lives at the same time, and doing it because of their care about what happens to our children. So, Senator Anderson.
I wanted to thank the author for bringing this up. We worked together in Budget Sub 5 last session on this very issue. So this follow-up is fantastic, and unfortunately, a senator jumped the gun, and I won't be able to move the bill. But otherwise, I would.
You can second that emotion.
Very good. Thank you, Senator Anderson. Any other debate or discussion? None other? All right, then, Senator, if you'd like to close.
I won't take any more of the committee's time. I think we've had a healthy conversation. It's clear about why this is critical. It's our role as elected leaders and policymakers in the state to protect the children within our charge, and that's our goal with this bill, and I ask for your favorable consideration.
Very good. Thank you. Madam Secretary, the bill is due pass to appropriations. Please call the roll.
The motion is due pass to Senate Appropriations Committee. Jackson?
Aye.
Jackson, aye. Vidak? Aye. Vidak, aye. Anderson? Aye. Anderson, aye. Hertzberg? Leno? Monning?
Aye.
Monning, aye. Wachowski? You have 4.
That bill has 4 votes. We will place it on call. Thank you, Senator. I think you'll be okay. Let's see, we need 4 to get out. All right, but we're going to hold the roll for other votes.
Thank you very much. I appreciate it.